presentation on preventing sexual harassment in the workplace and what to do when claims are made. I'm counsel for, we're all counsel with Jackson Lewis. I don't know why it says I'm associate. I'm actually of counsel, but I also work with my colleagues here who are going to be presenting here today, Marco Garcia and Xavier Cavalacci. I apologize, Xavier, if I'm not saying that correctly. And we are going to be here presenting today. And if at the end of the presentation, we'll reserve some time to answer any questions you may have. So feel free to either, raise your hand during the presentation if you have questions, or just save them for towards the end. And with that, I'll go ahead and turn it over to my colleague.
Good afternoon, everybody. My name is Marco Garcia. I'm going to go ahead and, before we get started with my main talking point with it, which is defining sexual harassment, is just go over a quick disclaimer. Here, the presenters have prepared the materials contained in this presentation for the participants' reference and general information in connection with education seminars. Attendees should consult with counsel before taking any actions that could affect their legal rights and should not consider these materials or discussions about these materials to be legal or other advice regarding any specific matter. And this is going to be the agenda for today. We're going to start off by defining sexual harassment. We're going to talk about the reporting the complaints, how to respond to complaints, how we can prevent sexual harassment, and end with liabilities and potential remedies. So what exactly is sexual harassment? Next slide. So the California Fair Employment and Housing Act has defined sexual harassment as a form of discrimination based on sex, gender, including pregnancy, childbirth, or related medical conditions, gender identity, gender expression, or sexual orientation. The Civil Rights Council regulation defines sexual harassment as unwanted sexual advances, verbal or physical conduct of a sexual nature. And sexual harassment may involve harassment of a person of the same gender or the harasser, regardless of either person's sexual orientation or gender identity. And that's pretty much the law behind it and how it's defined. But of course, it can be interpreted and conveyed in different ways that I'm going to discuss a little bit now. Next slide. And the types of harassment: quid pro quo and hostile work environment. With regards to quid pro quo, under California employment law, quid pro quo workplace sexual harassment occurs when a supervisor implicitly or explicitly requests a sexual favor in exchange for a job-related benefit, such as a promotion, increased pay, or a favorable performance evaluation. And later on, I'm going to have a slide specifically on that. And with regards to hostile work environment, a hostile work environment is a workplace where the words and actions of a supervisor, manager, coworker, or any other person create an environment that is difficult and uncomfortable, intimidating, offensive for another employee to work with due to the legal discrimination or potential sexual harassment that may occur. Next slide. So with regards to the quid pro quo harassment, it can look like this. For example, there can be another employee or supervisor who requests a sexual favor or advance in exchange for submission. That can look like a promotion, a raise, other favorable treatment, or it can be a request for sexual favor or advance. It can be an exchange of a rejection, such as a termination, demotion, or unfavorable treatment. For example, there can be a supervisor who asks an employee to engage in a type of conduct, sexual harassment conduct, and if they don't do it, then they're going to be terminated. Or in exchange, for example, hey, if you engage in this behavior with me, I will give you that promotion. Next slide.
Hey.
On a different time.
Stop.
The unwanted harassing conduct based on the protected status. The harassing conduct was severe and pervasive, and a reasonable person in the employee's circumstances will consider the conduct hostile or abusive. The employee considers the work environment hostile or abusive. And one of the biggest things here to look into is the severe and what constitutes severe and pervasive. For example, severe can be based on the offensiveness of a single instance of harassment. For example, rape or other violent actions may be severe enough to sustain a claim after just a single incident, whereas pervasive conduct is based on the frequency in which harassment occurs during a period. Less serious conduct, such as racist jokes or sexual comments, can uphold the claim if they repeatedly happen over a long period of time. Next slide. And then again, sexual harassment with hostile work environment, it can be based on sex and gender. It can be offensive, physical, verbal, or visual conduct. It's conduct that is unwelcome and conduct that is severe and pervasive. And here, the biggest takeaway that I want to discuss is, how, what actually is unwelcome conduct. In several instances, and the types of cases that we see is, in many instances, certain behavior may be actually welcome. Maybe two individuals are engaging in back and forth conduct, and it's reciprocal between both individuals. However, if it ever gets to the point where an individual is no longer welcoming the behavior, no matter if he or she said that, hey, this behavior is okay, and they've actually verbally conveyed it to a supervisor, the minute it's no longer welcome and they've conveyed it to a supervisor, certain action needs to be taken and that conduct needs to be addressed, even though it might have been welcome behavior in the past, especially because it can be lead up to being pervasive conduct that maybe in the first instance it didn't arise to being severe enough, but however, because it's pervasive in the sense that it's continuing on over a long period of time, it can ultimately cause an issue for you and your company. Next slide. And again, the types of harassing conduct, the verbal, visual, and physical. The first, verbal. If we look at some of the cases that we've discussed, this could be inappropriate comments or jokes, and it doesn't necessarily need to be a comment or joke directed at a particular employee for it to qualify as harassment. The second category, visual. This can be an image put up in a workplace, even if it's an image sent by a text message. And lastly, physical is any type of touching that could potentially be harassing. And those are the three for that one. Next slide. So what exactly is unwelcome and unwanted conduct? And we kind of touched base on this, but again, it's based on the subjective interpretation of the individual who is on the receiving end of the conduct. When the complaining employee says the conduct is of course unwelcome, that's the most clear-cut example of it. It's just judged from the perspective of the employee. It may not be unwelcome that the employee previously solicited or invited the conduct, which we did touch base on already. And again, at the end of the day, it's still likely against your company's policy. So regardless of whether it's welcome behavior or not, if it's the kind of behavior that is against the company policy that you're representing, you want to make sure you stop that behavior right away. Because at the end of the day, if it's ultimately the type of behavior that even though it's welcome, you don't want it to rise to the level where an employee later goes back, sues the company, and says it was ratified by the company. Next slide. Severe and pervasive. We've touched base a little bit on this, but just to kind of break it down again, it's the nature of the conduct, the frequency of the conduct, the circumstances under which the conduct occurred, whether the conduct was physically threatening or humiliating, and lastly, whether the conduct unreasonably interferes with the employee's work performance. And one of the things to consider here with regards to number 5 is, in certain instances, conduct that may be pervasive is the type of conduct that an employee might not necessarily physically or convey that it's an actual issue, but an employee might actually take certain steps to not work with an individual who they not feel comfortable with. They might start calling out on the days where another individual is working. They might request to work in a different section or in a different group and no longer be with a certain individual. And if it ultimately arises to a level of concern or enough where an employer or someone brings it to your attention, then this is something that must be taken note of and at least discussed with the employee to determine what the issue is. And these could be affirmative steps that the company can take to ensure that there's nothing necessarily going on. Next slide. And again, where can harassment occur? It can be at the workplace. It can be off premises for company-sponsored events, off premises outside of a work environment, and of course, online and social media. And one of the biggest things to consider, especially for like sexual harassment, is for work events. Typically, at the end of the year parties, people get together. There's certain supervisors who might want to continue going out with their employees after their work event, and that's something to just be generally conscious about, especially when giving advice to the employers or individuals you might be representing, is to be very careful in going out with these events and engage in certain behavior with employees. And obviously at the end of the day, they need to know that these events, even though it's outside of the work premises, if it arose from a work event and it continued on, the company could still be potentially liable for some type of sexual harassment that may have occurred afterwards. Next slide. So again, who can be a harasser? A coworker, supervisors, and third parties. And the next slide is going to be a video, and we're going to have a quick Q&A.
So, are you guys excited about the big move?
Yep, I already cleared my calendar for the clocking party, Saturday the 15th. Are you guys ready?
Oh, and everyone packing on the same day? That's going to be complete chaos. At least I got me one of those nice offices with a window.
Well, I have this whole plan. I found these amazing collapsible crates online, so I'm going to put my fragile stuff in one of them and take it home with me. I just want to be super careful with my stuff. I have 3 extras. Does anyone want to borrow?
I'm not going to be in on Saturday for the festivities, but I'll be in to pack up my workspace on Sunday. Would you mind leaving me a couple crates?
So what, no packing party for you, Ari? Man, that Sabbath thing really does come in handy, doesn't it? Maybe I should convert.
So is it just my religion you like to make fun of, or all religions?
Next slide.
So, are you guys excited about the big move?
Yep, I already cleared my.
So what should the bystander do here? Just based on that general comment and the way that the third individual came in and said something. Next slide. A, nothing, it doesn't have anything to do with her. B, tell the man making disparaging comments that they're inappropriate. C, redirect the conversation away from religion. And D, report the conversation to a manager. We have Tammy Evans. It says B, tell the man making disparaging comments that they're inappropriate. Anybody else? We have another B. And here, actually, the correct answer is D, report the conversation to the manager. Because even though it's something that maybe they couldn't indeed handle indirectly, it's better to address the issue and encourage employees to address these comments, because in all likelihood, even though that comment may be amongst those 3 individuals, there's a high likelihood that this type of harassing conduct, even though it's indirectly, it's a type of harassment conduct, it could occur in other instances. So if this type of conduct is addressed with a manager or supervisor, they can address this situation with the individual head on, as opposed to, allowing certain instances to continue to happen. So in this situation, we would actually want to encourage our supervisors, our employers, to make sure that they have that line of communication with the managers to report these certain instances. And next slide, I believe, Xavier.
Thank you, Marco, and thank you all for attending our presentation.
Xavier, we can't hear you.
Can you hear me now? Can you hear me?
Light, very faintly.
Okay, I'm gonna try to speak up. Thank you, Marco. Can you guys hear me?
A little bit better.
It was working before. Okay. Good afternoon. Thank you for attending our presentation. My name is Xavier Cavachi. I will be discussing how employees can report sexual harassment complaints, how to respond to sexual harassment complaints, and provide tips on how to prevent or minimize the risk for sexual harassment complaints. Reporting complaints. It is best practice to have clear written policies on how an employee can report sexual harassment. This policy should allow for employees to report sexual harassment to their immediate/direct supervisor, other managers or supervisors, including their direct supervisor, human resources, either directly or via a hotline, or any other member of upper management. The policy should not require the employee to report to a specific person or supervisor.
Xavier, can you open your laptop? It might be because it's closed that we can't hear you.
Okay, hold on one second. Is that better?
Yes.
Okay, awesome. Are the slides changing for you?
No.
No. Sorry for the technical difficulties. The slides won't change now. Hold on, let me see.
Do you want me to share my screen, Xavier?
Let me try. Okay. Can you see the
Yep.
slides? Okay.
Go ahead, try to toggle the next one.
No, now they're not changing. Yes, can you please take over the slideshow?
Okay, you're gonna have to
Here, stop share.
yeah.
Let's go back to number 19.
Well, I think you're on 20.
20,
Can we go to the
yes.
next one?
Yes.
Okay. Go ahead.
Okay. Okay, so next slide, please. Okay, so next, responding to complaints. Next slide, please. Just like reporting, it is best practice to have clear policies and procedures in place for supervisors and management to know what to do when they receive a complaint for sexual harassment. A typical response to a complaint is an investigation, which my colleague Laura will discuss in more detail later on in this presentation. Investigations should commence promptly. What is considered promptly? Well, it depends on the situation. More egregious conduct, for example, an employee groping another employee, typically requires a more prompt, almost immediate response. Less egregious conduct, for example, flirtatious text messages, asking a fellow employee out on a date over several days, a 1 to 2 day response time could be appropriate. Investigations should also be handled impartially, meaning treat the investigation, the complainant, the accused, and any potential witnesses equally and without prejudice. What if the complainant is a serial complainer or the accused is a serial harasser? It doesn't matter. Everyone should be treated impartially. The investigation should also be thorough. Every witness must be interviewed. Confidentiality must be kept throughout the entire process to the extent possible. And most importantly, the investigation must be done without retaliation, especially against the complainant or any of the witnesses. Next slide, please. Tips for handling employee complaints. Here are some tips for handling employee complaints of sexual harassment. First, thank the person for coming to you and make sure he or she feels comfortable. If the person starts to cry, offer him or her tissues and or some water. At the outset, reiterate the company's commitment to fostering a workplace free of harassment and ensure the employee that the company takes these complaints very seriously. Also, reiterate the company's policy ensuring that the employee will be protected from retaliation for sharing or bringing this complaint. After the employee is done, then let the employee share the complaint, listen actively, and reassure them throughout the process. After the employee is done sharing, assure him or her that the matter will be investigated and provide a brief explanation of the investigation process if necessary. Next slide, please. Depending on the situation, it may be necessary to separate the accused while the investigation begins. Do not separate the complainant, as this may be construed to be an adverse employment action, which will be discussed in more detail later on. Other things supervisors must not do include dismissing the complaint, excusing themselves from taking action, thinking someone else will handle the complaint, agreeing with the complainant. The investigation will reveal whether the claims are substantiated or not. Delay the complaint. Remember, complaints should be handled promptly. Forget about the complaint, or fail to ensure the complaint is being investigated. Next slide, please. Continuing on what not to do. Never treat a complaint as off the record or sweep it under the rug, thinking it would just go away. Even if the complainant insists that they do not want to make a big deal or they want to keep it anonymous, the duty to investigate is still triggered. When these situations happen, it's best to explain to the employee that the manager or supervisor has a duty to investigate and reassure the employee that their safety and well-being is the main priority. Next slide, please. Duty to prevent retaliation. Managers and supervisors have a duty to protect employees from retaliation resulting from the bringing of a sexual harassment complaint. Retaliation occurs when the employer takes an adverse employment action against an employee because they engaged in what's called a protected activity or created a hostile work environment. Next slide, please. So what is retaliation? So like I said, when an employer or another authority takes an adverse employment action against an employee because they engaged in protected activity or hostile work environment, which is conduct that is sufficiently severe or pervasive to alter the conditions of employment and create an abusive working environment, just like Marco discussed. Next slide, please. What are some examples of protected activity? This can include making the actual sexual harassment complaint, participating in an interview or in the investigation as a witness or as a complainant, or even making a complaint on behalf of a coworker who the person believes may have been subjected to sexual harassment. Next slide, please. What is an adverse employment action? So legally, an adverse employment action is anything an employer does to an employee that negatively impacts an employee's job, including the terms, conditions, or privileges. Some of the most common examples include termination, demotion, reduction in pay or hours, or even being placed on an unpaid administrative leave. Why would a victim be reluctant to report harassment? There are many reasons why a victim would be reluctant to report harassment, including ignorance of the law by either not knowing what sexual harassment is or the two types, being embarrassed or confused, having fear of not being believed, having fear of humiliation, having fear of retaliation, or having fear of losing their job or damaging their career opportunities. Next slide, please. Having strong anti-retaliation policies in place can help minimize these fears and encourage employees to speak up. Preventing sexual harassment. Next slide, please. Okay, so the unique role of management. Supervisors and managers should lead by example. They should set the culture. If it's okay for leaders, it's okay for everyone. The power dynamic is real. Always manage an issue and understand when the duty to act is triggered. Evaluate and advise. Baseline understanding for better evaluation of situations when they arise. Prevent discrimination, harassment, and retaliation, and avoid passive aggressive management. Sorry, next slide. The duty to act is paramount. Common mistakes include treating, complaints off the record, saying, let me know when you want me to do something about it, or sweeping it under the rug, saying, oh, do you want to make a formal complaint? The fact that an employee is going to you is an actual complaint, so there's no need to make it formal. saying, why don't you go back and write that up and we'll take it to HR? Again, the fact that the employee goes up to you as a manager, that's the complaint itself. Don't give advice as your friend or as mentor. Do not say it was more of a personal matter. They need to work it out. Do not say that was just hearsay. I have no evidence. I was not there. I did not hear it. And do not say I cannot act on rumors or gossip. And also remember, there is no waiver of the duty to act once you receive a complaint. That's all for me. I'll pass it on to Laura.
All right, thanks, Xavier. Make sure that's working. Okay. So we've talked about, what we've reviewed what harassment is, how to identify it, how to prevent it, implementing policies and procedures internally for reporting to prevent harassment claims and make sure they are brought to your attention. But what do you do once the claim is you're put on notice of a claim for harassment? Xavier touched on this a little bit, but generally speaking, when an employee makes an informal or a formal complaint about harassment, the employer should take immediate steps to stop the conflict, protect the interested parties, and begin an investigation. So I'm going to, how might an employer be put on notice of the claim? So there's, all these different options of how potential ways they might be put on notice. Sometimes you might get a call to HR, an email to HR. If you're a large organization, there might be like anonymous hotlines. You might receive a complaint letter. It might be in retention interviews, employee brings something up. There's all sorts of different ways it can come to your attention. So, just generally making sure that you have an anti-harassment policy to catch all those and invite feedback, pursue any unprofessional behavior by all employees, and, monitoring what's being posted in the workplace are all great ways to identify and, to catch those instances before they become insidious. So what I'm going to be talking about a little bit more in depth here is how to conduct an investigation of sex harassment, of a sex harassment complaint. So, as you know, there's many employer anti-discrimination, harassment, retaliation laws, and company policies that, require, that make that employers are legally obligated to investigate claims for harassment, discrimination, retaliation in a timely manner. Also, corrective action, if deemed warranted, should be taken to ensure any illegal behaviors are ceased immediately. Investigations are helpful because they not only give employers credible evidence to rely upon when making decisions about how to respond to those potential illegal behaviors and putting a stop to them, but they also boost the employer's credibility. If that matter were to proceed into litigation, it can also help employers flag systemic problems internally before some issue becomes widespread. Say you have one supervisor who is accused of being, of sexual harassment. One employee says, well, he was making comments about me to customers that made me feel uncomfortable about the clothes that I was wearing, or that I looked pretty and represented the company well, or something like that. And if that person who is doing that, maybe not even, intentionally thinking that it creates a hostile work environment or is perceived as harassing based off of that person's gender, is not, if that issue is not flagged to HR, he can continue doing it to other female employees, for example. So you want to, these investigations not have multiple purposes to help prevent and help employers be notified of systemic potential more broader issues. Again, every complaint has the ability to become a lawsuit. So every employer should investigate in a timely manner when they feel confident, in a manner that they feel confident they would be able to justify in front of a court of law. I know investigations can be costly and disruptive, but this is kind of one instance where a penny wise can be pound foolish. to not engage in prompt and thorough investigations. So anytime an employer receives a verbal or written complaint, they should promptly be evaluated. Let's see. So I'm sorry, I was going to run through the steps real quick. I'm going to talk about the investigations. So, the first step, obviously, we're going to, to ensure confidentiality. Step 2, provide interim protection. Then we're going to go into the selection of the investigator, creating an investigation plan, conducting interviews, making a decision, closing the investigation, and then developing a written summary. So I know Xavier already touched on these first 2 steps, so I'm going to just glide through them real quickly. But again, ensuring confidentiality is paramount, but we never should promise that to the employees, because the best way to phrase it is if someone says, well, I want you to keep this confidential, please don't tell anyone. You can explain to them that the information that they shared will only be shared on a need-to-know basis, but you may have to share that information in order to conduct a thorough investigation. So this complainant is going to give you a list of 10 things that the person did, and that that they're saying this is evidence that they're discriminating against me because of my gender or something like that. You have to be able, conducting that investigation, you have to be able to ask each witness, not only the alleged perpetrator, did this happen, but you also have to be able to ask all the witnesses, did you hear about this happening? Did you know about this happening? So you can't promise confidentiality. Also, Xavier touched on this too, but when you're doing an investigation in response to a claim for harassment or discrimination or retaliation, you need to make sure that the complainant is being protected, take immediate steps to make sure that they're not going to be retaliated against. A common mistake is employers will, I know Xavier touched on this too, but a really common mistake is they'll put the claimant on paid admin leave and say, well, that way you can't be harassed anymore while we're conducting this investigation. That could easily be construed as retaliatory. It should be the perpetrator that is, if someone's going to be put on paid admin leave, it's got to be the perpetrator. I mean, every scenario is different, so I shouldn't say that that's always the case, but just generally speaking, you want to avoid discriminating any retaliation claims by the claimant. Always a good philosophy to consult with outside counsel before you make any decisions on what to do, with those, and for providing interim protection. Another thing that comes up common in these investigations is maybe the complainant might hire a lawyer mid-investigation, or they refuse to participate in the investigation. That happens, but as the employer's obligation to complete a timely and prompt investigation, you can't let those hurdles stop you from continuing with your investigation. Sometimes the claimant might have his attorney want to be present during the investigation. Again, these are all things that you probably should discuss with your outside counsel before agreeing to. But the point I want to bring home is that it's really important, it's really paramount to engage a timely and prompt investigation and see it through to fruition, regardless of those kind of hurdles that might come up. Okay, so how do you select an investigator? It really depends on your organization. What's your size? What's your capacity? Do you have someone who has no stake? Like if you want to do some internal, maybe you want to save the cost on hiring an outside investigator. Do you have someone internally who has no stake in the outcome, who can proceed unbiased in doing the investigation? They have the experience to be able to conduct an investigation and a working knowledge of employment laws. Usually that's going to be an internal HR staff person if you're going to do it internally. Common mistake I see is employers have management do it, and management does not always know the ins and outs of employment law. They don't know the correct questions to ask. So there's just so many issues that are left on the table. And then it ends up into a lawsuit, and you're like, well, if we had only known this stuff back then, we might have made a different decision. Hindsight's 2020, but if you hire someone with or engage someone internally that has the experience to do that investigation, it can really impact your decision going forward. Some considerations to take into factors to take into consideration. when evaluating whether or not to use an internal HR person as opposed to hiring an outside third-party investigator company or outside legal counsel. The pros of using an internal staff member is obviously they have a good working knowledge of your organization. They likely have good interpersonal skills because that's what brought them into the HR field to begin with. They're also familiar with your organization and the employees. The cons to using an internal HR person is they could be perceived as not neutral because they have connections to management. And then there also can be conflicts that arise too, because they might be a witness in the investigation. Using a third-party investigator is generally used when the employer doesn't have someone internally to conduct the investigation due to like staffing. Maybe you don't have an HR department, or maybe when the accusations are against like senior leadership. Legal counsel or in-house counsel or outside counsel, those can be really good options too. I'd say that's probably the best option if you can afford it, just because they'll bring objectivity, they know the law, they know the right questions to ask to make sure that you really get a thorough understanding of the lay of the law, of the lay of the land with the claim. And the cons is they could have ethical and privilege considerations that you have to take into consideration. They have to disclose, for example, they have to disclose for the purpose of the investigation that they are the attorney of the employer and that there's an attorney-employer relationship and that the organization is their client. So they might come across as a little bit more, biased in that respect. They may not be familiar also with the workings of the organization and culture, so you're going to have to kind of bring them up to speed a little bit more. And they can be perceived as intimidating too. Just talking to a lawyer, a lot of people just don't like it. Okay, so what do you do to create an investigation plan? So first, you want to outline the issues. What's the specific conduct being asserted? Bullet point those. Develop a list of those witnesses that are implicated. If you got a report, an email from the complainant listing what the complaint is, who's mentioned in those? What documents do they reference? Do they reference any text messages or emails with the alleged perpetrator? Create a list of all those documents that need to be reviewed, all the witnesses that need to be interviewed, and the specific conduct that needs to be evaluated. Then once you look at all that, the big picture, then you're going to determine what questions are crucial to ask. The who, the what, the when, where, think of all those questions, the 5 W's. Who are all the witnesses to the events too? What documentation exists to show these incidents that you're alleging occurred? What are all the ins and outs of what was communicated? What are all the facts that we need to know about surrounding this claim? And then the other thing is you really want to make sure you implement a process to ensure any documents are being retained, particularly when it comes to electronic, communications, emails, Slack conversations, Teams messages. You want to ensure that those documents are being retained because you don't want to be tagged with a spoliation of evidence claim. The most common one I see come up in litigation is video footage. Claimants always think that everything's been being recorded and can prove their allegations because it's on video somewhere. But it's so common for employers' video footage to roll over itself after a week or 2 weeks or 30 days. They have kind of this automatic data reoccurring cycle. And so you lose that. So if the claimant brings it up during the investigation, I think there's video footage to show X, Y, and Z occurred. Just make sure that you promptly and timely contact your IT department to make sure that those documents and video footage are being preserved. Okay, how do you start the investigation? So always start with the complainant. Interviewing them, you want to make sure that you understand exactly all those complaints. So use your outline that you prepared, go over every single allegation, And you don't move on to the next allegation until you're fully satisfied with that you understand all the facts that are being asserted, who said what and who said when and when, in regards to this specific allegation, who are all the witnesses to those alleged people who have witnessed these events, or what documents support that these events occurred, and those three issues. So facts, documents, witnesses for every single claim. Interview percipient witnesses next. That's going to be the folks that are identified as having peripheral knowledge to, or firsthand or secondhand knowledge to the alleged allegations. Then you're going to conclude the investigation with the accused. You're going to run everything by that person, find out what their response is, and then there oftentimes when you interview the accused, there's going to be counter allegations. You're going to have to follow up interviews. Oh, they're going to say, oh, that witness wasn't there. That's not true. Well, to evaluate the credibility of that witness or the claimant, you're now going to have to follow up and talk with that witness again. Wait, someone says you weren't there. Were you really there the day of the alleged complaint, or the alleged incident that happened? And so those are all just important things to do to follow up, to identify and clarify any issues arising from any inconsistencies that come up during the investigation. So I just included 2 tips here. I was like, 1, focus on being impartial and objective to gather facts and evidence. Don't offer opinions or say anything that would discredit your impartiality. Sometimes you want to offer them you want to offer the complainant or individuals, you want to make them feel comfortable. So you might say things that might later on be perceived as partiality or biasness. So just try to avoid those. Second tip is because the role of the investigator is to determine the credibility of the witnesses and the employees being interviewed, details are very important. Oftentimes you come up to the end of the investigation and you don't, one person says one thing happened, there's no witnesses, the accused says nothing happened, that's not true. Well, who do you believe? That falls down onto the inconsistencies, the credibility of the witnesses. Is someone being inconsistent on other issues? Well, that can factor into their credibility as to whether or not they should be believed over the other person. And then you're gonna have to make a decision. So after all the interviews are completed, all the evidence is collected, and all issues of credibility have been resolved, meaning that if there's inconsistencies that have arisen while you're doing those interviews, that you've gone back to clarify them as much as possible, and that now they've been resolved. Oh, maybe that witness wasn't actually there. They forgot they left work early that day to take their daughter to a doctor's appointment, right? Something like that. So then the investigator will make a formal recommendation. When that happens, usually they'll do a call with outside counsel and inside counsel or your HR department to communicate the results of their investigation. That scenario, I'm using the example if you're using a third-party outside investigator. They will tell you from each, 9, 10, incidents that were alleged, or, factors that, or, complaints that are being asserted, whether or not they were substantiated or not substantiated. If they're substantiated, whether the conduct violated any of the employer's anti-harassment, discrimination, or retaliation policies. Then they'll also identify whether there are any steps necessary to prevent further harassment, and then they'll whether or not there's any disciplinary action warranted. I would say always make sure that you're consulting with legal counsel on this. It's a good idea to rope in your outside legal counsel on this call, that you have with the outside investigator to find out all the ins and outs of, why the claims are substantiated or not substantiated, what supports them, so that you can rely on their expertise when making a decision to ensure that if you're going to go down the road of disciplinary action, that understanding all the legal implications of doing that. So then you're going to step 7 is closure of the investigation. You'll need to communicate the results of the investigation to the claimant. It's important to let them know that the organization always takes those complaints seriously, whether or not it was substantiated or not. They always take the complaint seriously and take appropriate action. You always take appropriate action. It's a good idea to always ensure that the complainant agrees with you when that they feel that they were heard or understood. And a good way to kind of just wrap that up is just like asking them, do you feel, we wanted to make sure that we felt that you were heard, that you were understood. If you don't agree with that, can you let us know? But we want to, even if they don't agree with the results, you want to make sure that they've confirmed to you that they feel like you heard and understood what their complaints were. Finally, you want to schedule a follow-up call with them to ensure that there's no further issues arising as they settle back into the work environment. With that, maybe you're going to bring the alleged accused back to the workplace, and you want to make sure that there's no further incidences that are arising. Maybe that person comes back and they're told not to work with that claimant anymore. Follow up with them a week later, make sure, hey, I'm just checking in, how are things going on? I want to make sure that there's no other incidences that have happened that we need to be aware of or anything like that. And just kind of touching your basis on that. Again, it's always helpful at this stage to, again, remind everyone about their obligation to preserve confidentiality. The witnesses, the accused, to ensure that they're not talking about the confidential information that was relayed to them during the course of the investigation. Okay, and then lastly, so the last step is to, really rather decide whether you're going to develop a written summary of the investigation results. Reports can be helpful for preventing claims against failure to prevent harassment, retaliation, or discrimination, which those claims can be wholly separate and independent from the underlying harassment claims or discriminations or retaliation claims. So a failure to prevent harassment, discrimination, or retaliation claim, those can hold employers accountable for not taking any reasonable steps to prevent conduct found to be harassing. So reports that document findings after you're doing these investigations can be kind of like insurance policies against those claims going forward. Keep in mind that those investigators those investigation reports can be discoverable. So it's always advisable to consult counsel before deciding whether or not to memorialize the findings of your investigation into a written report. But generally, they should be covering, if you do decide to do a report, generally, if it's very favorable, your report should cover, what was the issues that were investigated, all the parties involved, witnesses interviewed, factual findings, the employer's policies that were relevant to the investigation. Say you had a supervisor that violated a use of company devices, policy, and that's now he's going to be disciplined for that or something like that. Maybe he didn't find any harassment actually occurred. There was no violation of the anti-harassment policies, but maybe he violated that other policy and he needs to have a write-up for that. So those specific conclusions are all identified and written out in the paper, in the report. So just lastly, again, keeping a paper trail of the evidence, keeping all that document preserved is really, all those documents preserved is paramount, but keeping a paper trail of the investigation process and what documents were used, what was considered, all in one file so that it's easily accessible and transferable to your outside counsel. In the event litigation arises, you can just drop and send them everything, all those emails, all those attachments, all those voicemails, everything that was relied upon for that investigation, all just in one pile, one file. And so for the report, focus on objective, relevant facts. One thing I'll see commonly in just write-ups or reports, investigation reports, is using really subjective terms like the employee was being disrespectful. Well, how were they being disrespectful to their supervisor, to this alleged to the claimant? What specifically conduct was happening? Don't just use these like broad, like vague terms to kind of but you want to focus on just the very objective analysis. All right, so we've got about 7 minutes left in our time here. I wanted to open up the floor to see if anyone has any questions. I'm going to look in that chat room to see if that pulls up any. Okay, hold on. Okay, if you have any questions, just pop them into the chat room. And if not, then we can just chat about some fun examples from our experiences. Well, while you guys are thinking through some potential questions you might have, I was going to share one example where an investigation really helped an employer identify a systemic issue that I had. I'm not going to obviously share the name of my client, but I had a case a couple years ago where a supervisor was accused of sexual harassment. And once I worked with the client, pulled in an outside investigator. They did a thorough investigation, and they started, came to a conclusion. There was no harassment specifically found in this case, but because there was just all very he said, she said scenario, and none of it was able to be corroborated. However, it did raise flags because from a systemic issue, that there were other people who throughout that investigation process also had complaints about other people within the organization making kind of disparaging comments. So while it didn't implicate the original accused and the complaints and substantiate their complaints because it wasn't relevant, it did identify a systemic issue within the internal organization that just generally there was a culture of the inappropriate comments that were being made internally, and that needed to be addressed. And so because that one investigation led to that conclusion, I put that employer in contact with a professional to help culture coach and to help train management to make sure that to break that cycle of that type of conduct, because if you don't break that cycle, you're just going to end up with more and more harassment claims. All right. Xavier or Marco, do you guys have any fun examples to share?
Nothing necessarily fun. I wouldn't label it that way. But
entertaining, I should say, rather. Well, if any of you guys have any questions about this presentation or what to do in response to, harassment or even a discrimination or retaliation claim, you have our contact information. Feel free to email any of us about, and we can, that's what we do here at Jackson Lewis. This is our bread and butter. We litigate, defend, and these types of claims, sex harassment. We can walk you through connecting you with an outside investigator. We can oversee that process to ensure that you're being advised appropriately along the way. And if litigation ensues, then defend the case thoroughly for you all. So thank you all for your time here today. And if no one else has any questions, I guess we'll just leave the floor open. Audrey, are you guys going to be sending around the link for this to everyone who might want to see a recording or a copy of the presentation?
Yes, a copy of the presentation will be posted on the ACC website.
Excellent. Okay.
Thank you very much.
Thank you all. You all have a wonderful rest of your day.